Queensland's anti-discrimination reform, a necessary delay or unnecessary burden. The Queensland government's indefinite postponement of crucial anti-discrimination law reforms has ignited a firestorm of controversy. These reforms, meticulously crafted over 3.5 years by the Queensland Human Rights Commission following a public outcry, were intended to bolster protections for vulnerable groups, including victims of domestic violence, the homeless, and women in the workplace. The catalyst for this extensive consultation process was the highly publicized scandal at Brisbane's Citipointe Christian College. The college's controversial demand that families sign a statement condemning homosexual acts as immoral exposed significant gaps in existing legislation and fueled the urgent need for comprehensive reform. Attorney General Shannon Fentiman's recent statement, citing the potential for unnecessary burden on organizations and institutions, has further exacerbated the situation. Critics argue this justification undermines the very purpose of the reforms to ensure equitable treatment and prevent discrimination against marginalized communities. The delay, they contend, sends a chilling message, suggesting a prioritization of institutional convenience over the fundamental human rights of vulnerable individuals. The proposed legislation aimed to significantly broaden the scope of anti-discrimination protections, addressing systemic inequalities that have long plagued Queensland. Its postponement leaves these vulnerable populations exposed, potentially exacerbating existing injustices. While the Attorney General's concerns regarding potential burdens on organizations deserve consideration, the question remains: should the potential inconvenience to institutions outweigh the critical need to protect the rights and safety of vulnerable individuals? The lengthy consultation period, involving extensive input from various stakeholders, should have anticipated and addressed many of these concerns. The resulting delay raises serious questions about the government's commitment to upholding human rights and protecting its most vulnerable citizens. The government's responsibility lies not only in mitigating potential burdens, but also in actively safeguarding the rights and well-being of all Queenslanders, regardless of their background or circumstances. The indefinite postponement casts a shadow over the government's commitment to social justice and calls for a transparent and timely explanation justifying the delay and outlining a clear path forward. The public deserves answers, and the vulnerable populations affected deserve immediate and effective protection. The government's actions, or lack thereof, will determine whether this delay is viewed as a necessary recalibration or a betrayal of its commitment to equality.